Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. International regulation of maritime law. Maritime law is often thought of as being a species of international law rather than a branch of domestic or municipal law. It should not be denied that the international aspect of maritime law gives it a distinctive flavor. In doubtful cases, court of one country will often look to the precedents for or statutes of another country for inspiration or guidance. Except to the extent that it may have bound itself by international convention, however, each country has the right to adopt such maritime law as it sees fit. Although many such laws are common to most maritime countries, others are not, though there is a growing tendency to restore the international uniformity in the maritime law achieved during the Middle Age. In many areas, the lead has been taken by the International Maritime Committee, more commonly known by its French name Comité Maritime International or CMI, which is composed of the Maritime Law Association of more than 30 nations. The work of the committee consists principally of drafting international conventions relating to subjects of maritime law. When such a draft is prepared, it is submitted to the Belgian government, which then convenes as a diplomatic conference at which the CMI drafts is discussed and amended as the official delegates may decide it. If the revised draft wins approval at the conference, it is then submitted to the national governments for possible ratification. Although many of these conventions have failed to be widely ratified, others have been highly successful. The International Regulation for the Prevention of Collisions at Sea, first adopted at any international conference held in Washington in 1889 and revised at Maritime Safety Conference held in London from time to time since 1914, are recognized by all of the maritime countries. The regulations are, in effect, an international code of navigation. In other fields, much has been accomplished to ensure international uniformity through private agreements voluntarily adhered to by effect interest. The York Antwerp Rules of General Average, first promulgated in 1890 and most recently amended in 1950, are the best known example of such agreements. Although they do not technically have the force of law, nevertheless, by incorporation in charter parties and bills of lading, they determine the rights and obligations of the parties as effectively as any statute. High seas in maritime law, all parts of the mass of salt water surrounding the globe that are not part of the territorial sea or internal waters of a state. For several centuries, beginning in the European Middle Age, a number of maritime states assert sovereignty over large portions of the high seas. Well-known examples were the claims of Genoa in the Mediterranean and of Great Britain in the North Sea and elsewhere. The doctrine that the high seas in time of peace are open to all nations and may not be subject to national sovereignty or freedom of the seas, was proposed by the Dutch jurist Hugo Grotius as early as 1609. It did not become an accepted principle of international law, however, until the 19th century. Freedom of the seas was ideologically connected with other 19th century freedoms, particularly laissez-faire economic theory, and was vigorously pressed by the great maritime and commercial powers, especially Great Britain. Freedom of the high seas is now recognized to include freedom of navigation, fishing, the laying of submarine cables and pipelines, and overflight of aircraft. By the second half of the 20th century, demands by some coastal states for increased security and customs zone, for exclusive offshore fishing rights, for conservation of maritime resources, and for exploitation of resources, especially oil, found in continental shelf, caused serious conflicts. The first United Nations Conference on the Law of the Sea, meeting at Geneva in 1958, sought to codify the law of the high seas but was unable to resolve many issues, notably the maximum permissible breadth of the territorial sea subject to national sovereignty. A second conference in Geneva 1960 also failed to resolve this point, and a third conference began in Sarasas in 1973, later convening in Geneva and New York City. In international law, that area of the sea immediately adjacent to the shores of a state and subject to the territorial jurisdiction of that state. Territorial waters are those to be distinguished on the one hand from the high seas, which are common to all countries, and all the other forms internal or inland waters, such as lakes wholly surrounded by the national territory, or certain bays or estuaries. Historically, the concept of territorial waters originated in the controversy over the status of the sea in the formative period of modern international law in the 17th century. Although the doctrine that the sea by its nature must be free to all was eventually upheld, most commentators did recognize that as a practical matter, a coastal state needed to exercise some jurisdictions in the waters adjacent to its source. Two different concepts developed: that the area of jurisdiction should be limited to cannon shoot range, and that the area should be a much greater belt of uniform width adjacent to the coast. And the late 18th century, this concept coalesced in a compromise view that proposed a fixed limit of 3 nautical miles. In 1793, the United States adopted 3 miles for neutrality purposes, but although many other maritime states during the 19th century came to recognize the same limit, it never won such universal acceptance as to become an undisputed rule of international law. In the course of this historical development, it became settled that the belt of territorial waters, together with the seabed and suboil beneath it and the airspace above, is under the sovereignty of the coastal state. This sovereignty is qualified only by a right of innocent passage, that is, peaceful transit not prejudicial to the good order or security of the coastal state, for merchant vessels of other nations. The right of innocent passage does not apply to submerged submarines or to aircraft, nor does it include a right to fish. On the width of the belt, there has developed no universal agreement except that every state is entitled to a minimum of 3 nautical miles. Claims in excess for 12 nautical miles or 22 kilometers commonly meet widespread opposition from the other states. Tough in the 1960s and 70s, A trend to a now A trend to a 12 nautical miles limit was evident among about 40 states taking this view were China, India, Mexico, Pakistan, Egypt, and the Soviet Union. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.